Namaste Bharat. I am Srimati Duvuri Vatsalendra, Senior Lawyer, High Court of Telangana. I don't think most of you ever have known to something like called easement rights. Now, let me explain to you. Easement rights are the rights accrued to a movable property of an owner who actually can protect his rights. Rights, when I say, they are multiple rights. Now, most commonly is the right to light, air, egress, ingress, which I mean going out of your property, coming into your property, and also the rights which you actually you transfer the rights on a temporary or a constant basis, a proprietary, or even heritage rights. Now, if I have to explain in a very transparent mode, it is rights which we get by virtue of natural air, natural waters, natural lands, and even the open lands available for cattle grazing. Now, let me first explain the simplest easement right which we face on everyday basis, that is the right to air. Now, we know when we have our own property, a house, independent house, or a flat, apartment, or anything, any other person, third person, obstructing the light, air, water to your property is a common, which is non-constant right, which means that is your personal property, which though you're constantly living there, some obstruction may be constant or not constant. Any constant obstruction should be immediately removed, under which you call for your right under Easement Act. Now, there are various categories of easement rights. When I say, sometimes the landowners, agricultural landowners I mean, have properties, a land may be at a higher elevation, the other may be at a lower elevation. When I say high and low, when natural water harvests or falls onto the higher landowners and they obstruct path for this natural waters to flow to the lower elevated lands or agricultural lands, then even this lower faced landowners can ask for their rights to this natural source of water, the water to be supplied to them in a natural atmosphere. These rights cannot be prevented or stopped by the high elevated landowners or the agriculturists, which is in benefit of everybody. Now, apart from this, the agriculturists who graze their cattle can let their cattle have their grazing into an open land, which is no man's land. The cattle can feed there on the grass which is available on that particular land. No in and around area landowners or the agricultural landowners can raise any kind of objection. Suppose such lands, by virtue of any governmental right, are taken away by the government, in such circumstances, the cattle should be prevented from going to that land and being grazed. And apart from this, proprietary rights. Now, I am a proprietor of an office or a company. I take care of all the happenings in the company as a right given to me as proprietor, but I do not own the land or the property or the company. In such circumstances, I am responsible to be answerable under easement right of only holding myself as a propriety not a total authority or the owner to such company or its requirements. Anybody whose rights are affected by my acts as a proprietor can also be challenged under easementary rights. Apart from this, suppose I give a building, heritage building, for a long lease, the right will automatically transfer to the person to whom I have given under lease, which crosses more than 20 years. And that rights and benefits of that building, though, will come to me over a period of time, say crossing more than 20 years or 30 years. The person who has actually taken the building under lease, automatically the rights can be transferred or alienated to third persons, as the leaseholder to such things comes into the owner's footing. So I hope I am clear here. This apart, there are certain rights which are accrued under easement rights, like there will be a license holder and the grantor. The license holder will accrue a right under license by the grantor for a certain period. I will enjoy such lease of the property in any which way that I want to use under the lease deed, which is termed and stated. Suppose the grantor unilaterally, cancels such the rights under the lease, the leaseholder or the licensee will have right to ask for damages for unilateral cancellation or before the termination of such lease rights. Apart from this, I'll tell you something, that there are exclusive rights. Now suppose I am a building holder which exclusively belongs to me. No other person shall cause any sort of inconveniences, like trying to create a big wall in front of my building where my right to light, or cause some sort of pipeline damage which supplies water to me, or power, or air, by cocooning me from all sides, which are my exclusive rights. So henceforth, when we see this, when the municipals grant permissions, there are something called setbacks. These setbacks are nothing but to give that particular owner the comfort of having to enjoy all these rights. As I said, not only this, when I say in a building an apartment, my neighbor cannot obstruct my entrance to my flat by putting a structure, permanent structure, or even non-permanent structure, to cause my movement or my light, my air, or water supply can be disconnected for my single flat, which cannot be done, and it can again be challenged under easement rights. There are many such rights created under easement rights, which we can challenge and speak about under this act, not to court. As I said, there are multiple acts of easements, and as such I am only giving you in part so that you actually understand that there are certain rights under this to be known and challenged in the courts of law. I hope you understand that you have these rights. Namaste.